Hello, my name is Rene Garcia, and welcome to our session here about contract management. I'm going to go ahead and put my screen up and kind of start the process. Hope you all are doing well today. So we're going to talk about contract management, and I have a little agenda that we'll go through. I can get it to advance. I thought what we do is just go through a quick introduction of what the topic is and just some bottom points, and then talk about the life cycle of a contract. It's really important to understand where it starts and where it ends, and then get into a little bit of material that tells you, what the regular terms are that you would run into in a construction related type contract, and then get into a little case study that I think will be helpful to try to bring everything together, and then allow some time for questions and answer. I know that the Maestro team is taking questions as this goes along, and there's a chat screen too, I believe. So as we go through this, just feel free to throw questions out, and we'll try to get to those at the end as best as possible. So introductions. My name is Rene Garcia. As I said before, I'm the president of DreamOn Development Company and a vice president with Tejas Premier. But I'm a founder with Julissa Cariello of the DreamOn Group, which is basically an overall company for this series of companies that we have. I have over 35 years of experience in construction and real estate development. So a lot of what I'm sharing today is just based on information that or experiences that I've had, knowledge I've gathered from a lot of smart people, and hopefully it'll be helpful for you. One of the things that I'm trying to do too in this presentation is give you some material that you can refer to later, some checklists, some things to really look back at as you're going through negotiating contracts, so that you can make sure you've got a template of some kind to follow as you go through your process. I assume that most of you are in the construction industry because this is a construction related forum. You may be subcontractors, you may be service providers, you may be vendors, but I think for the most part, you're going to have some type of purchase order contract as you do business. So hopefully this will be helpful for you. So Einstein said, there's only one road to human greatness, and it's through the school of hard knocks. So that's my way of a disclaimer. It tells you I'm not an attorney. I'm a licensed engineer, and I have a master's in business. But more than anything, I've got years of experience working on pretty sophisticated projects, and hopefully this will help. So I'm bringing this to you more from the perspective of a business person like you. Again, I'm not an attorney, but I've learned a lot over the years of how to manage, how to work through projects with attorneys, and that's really the perspective or the way that I'm approaching this presentation. So I don't speak legalese, I speak business. So I hope that translates good for you. So the life cycle of a contract. So why do we have to have a contract, and what's involved with that? So the way that I look at it is that, we get into projects, or we get into situations where we're working, with clients, and we're basically on an adventure, on a journey, and we know where we're trying to get, we know why we're trying to get there, we know why we're in business. And a lot of times we don't really see the full effect of what it is that or the circumstances that we might be in, and the consequences of some of the things that could happen that we're not thinking about. So this is an image of two young ladies that are having fun climbing a cliff. They planned this very well. I mean, they spent a lot of time getting there, being prepared, getting on the cliff. They feel like they're ready to do this adventure. What they may not have understood is really what's at stake. What happens if something were to go wrong? And incidentally, the young lady on the left is my daughter. So you can understand as a father how difficult it is for me to look at this picture. But I know that one thing is for sure, that she's an engineer too, that she's thought through this, and she's taken into account all the consequences that could happen. So what's interesting is you've got these base jumpers that are on the bottom of this screen, and that's really what she's pointing at. This is a whole nother story in itself, but the point of this is to know that when you get into these contracts, you need to really understand the details of what you're getting into and what the consequences might be. So what is a contract? It's a legally binding agreement. And what it does is it outlines what the remedies are in the event that there's something that happens that differentiates from what you agreed to or what you thought you agreed to. So This material is going to be provided to you. I'll let you read all the words when you get it. I'm going to try to move fast through this. So managing a contract, there are steps to doing that. There's the whole preliminary information, pre, post, contractual. There's a process for doing that. Why do you have to have a contract? It provides a description of each party's rights and responsibilities, very detailed, but it also goes into being able to put that in a way that abides by the laws and the statutes that are provided for us to operate under as a business. So it establishes timelines, deadlines, you know up front what the expectations are with respect to what you're delivering and when you're delivering it. It describes very specifically what happens if there are problems or issues. It lays out how you're going to be compensated for whatever service or work that you're doing, and who's responsible for paying you and when they're responsible for paying you. And it really helps you manage, in the event that there's some kind of a dispute, it helps you manage the process of closing out that dispute. So if you get into a big argument and you can't rely on anything but the legal processes, there are third-party groups that you can go to that help you get through that process. They're a lot less expensive than going through a full court case in the event that that's if it's a big issue, that is. So the life cycle itself, it always starts with initiating a contract. So you've submitted a proposal, you've identified a project, you know that there's a process that you want to go through. The next step is understanding who's legally responsible or obligated, authorized really to sign these contracts, who can negotiate them. So you don't want to be negotiating with somebody that isn't authorized to do that. So because it would make the contract null and void. You go through a process of understanding the contract, the terms in the contract, negotiating it, reviewing. You turn the contract, which means you take turns editing and reviewing the contract, making sure that it represents what you believe you're going to be doing as service for the contract. You execute the contract. Then you start doing your work, and you manage your work in accordance with that contract. If something changes during the course of that contract, the scope, additions, change orders, timelines, delays, whatever that is, those need to be handled very specifically through amendments in the contract. And once you've gotten through the contract, there's a termination or an end to that contract. So you need to understand at what point are your obligations finished with that contract. So very general, but this is kind of the life cycle. And what I see and what I've learned over the years of working on contracts is there's some very specific terms that I look for. And this is basically the skeleton of what you would typically see in a construction related contract. It would generally, somewhere in the contract, there's definitions of terminology, because words may mean something different to different people. So it's real important to understand clearly what some of the words that are being used. Words have legal content or context. So you have to understand why words are being used. And we'll talk a little bit about that. There's discussions about what happens, up front. There's, what are you binding yourself to? If there's any documents associated with the work you're doing, what the requirements are for bond and insurance, all these things that are on this change of work. Some of the things that we talked about was inspections are required, how to handle dispute resolution, and then whatever miscellaneous other items might be involved with the project, which sometimes it's forms, or it's certain conditions of how you can work in a facility. It's different things that might be a party or part of that contract. These are the things that I generally spend a lot of time on. It's what are the owner's responsibilities as it relates to the contract, making sure that what's defined in the contract is correct as far as the cost of the work that I've committed to. And then really, how do I get paid for that work? What are the things that I need to do in order to satisfy the owner's requirements for getting payment? And if you've been doing this for a while, you know that there's a lot of paperwork generally that goes with, especially if you're working for public entities, and it's all justified, but you have to understand what those are. Private entities are the same. They have lenders, they have other obligations that they have to do. So it's good to understand what their needs are to get paid, so you don't get slowed down on payment. So there are things called verbal contracts versus written contracts. We generally, I think in our business, don't really do a lot of verbal contracts. There was a time when that was probably, acceptable, but either way, verbal contracts rely on good faith. And so that's why for the business that we do, I would recommend that you not rely on verbal contracts. I think unless you really have a reason to do it that's justified. For the most part, in our business, as professionals, as businesses that are thriving, we'd like to get everything in writing. What constitutes an agreement? It's to have these on the left-hand side. You'll see that there's 4 factors. There has to be an offer, so there's got to be an offer. So if you're a contractor, you're providing a proposal. There needs to be an acceptance of that proposal in writing from the opposite party, which would be an owner or a client or someone like that. And then there has to be an intention to create that relationship. So that's where a contract comes in. And then in that contract, there's what they call a consideration, which is really in the form of monetary. So there's an exchange of money, for example. So those are generally the things when you talk to attorneys, they'll tell you are the basis of a contract. Things that would make the contract invalid, or if someone's enticed to commit a crime through the contract or something that's illegal, would automatically invalidate that contract. Enter into someone that lacks the capacity. Well, I mentioned earlier that if you're not authorized to sign the contract, then it could make the contract invalid. And then if you provided misleading information or deceptive or any kind of fraud, that would also be a cause for making the contract invalid. So I don't see that too often. It's not really the nature of the business that we do in our industry, but it's just something to be aware of. General terms in the structure of a contract. Again, these are just lists that I'm providing you just as a reference, something that you can refer back to as you go through your life. Negotiating contracts, it's having details of the parties to the contract, understanding, who the partners are, who the relationships are with. We talked about it before. Duration of the contract, being very specific, understanding the definitions, the payment details, the key dates. What guarantees are being provided, what bonds, what happens in the event that there's damages, insurance clauses, who steps in, what kind of deductibles do you have? Are there renewals to the contract, and understanding how long this contract can be extended? All these things that are up here. So it's a good list. It's something to really think about. So now I'm trying to give you a little highlight on what I generally try to follow is when I start working on contracts, and it's that I really try to sit down. It's difficult. Doing contracts is not one of my most favorite things to do, but understanding that it's important to read the contract. What happens though, as you do more and more contracts, you get very familiar with the language and you're able to read through it a lot quicker. So the first few times is difficult if you haven't read a lot of contracts, but it's important to really understand every aspect of what's in that contract so you're not surprised. You don't want to be on the other end of an argument when they pull out the contract and show you something that you signed and you weren't aware of that clause. So as you go through and read it, you have to really make sure that it reflects what you understand the deal structure is. If there's something in there that isn't clear, doesn't feel right to you, a lot of times it's just a gut feeling about something that you read that you don't understand. It's important to have that conversation with the other party to clarify and make sure that it's clearly identified in the contract what the agreement is. So when you get to, there's a lot of times, even now for me, I've been doing this for a while, where there's terms in there that I know are legal terms that I don't have an understanding of, words that are being used, clauses that are being used. And so I seek the advice of an attorney to give me feedback on that. I think managing your relationship with your attorney is important. You can have attorneys do all this for you, but I would not recommend it. I think you should do it yourself. And it gets real expensive when you have attorneys doing all this for you. So it's good to practice this negotiating and understanding contracts so that you can do a lot of it yourself and only rely on attorneys when you need them. And they're always there. There's a lot of great attorneys out there. So give yourself time. Don't get forced and backed into a corner into not being able to do these things that I'm mentioning so you have the opportunity to really understand what you're obligating yourself to. Don't get pressured, same thing. Don't leave anything blank. You don't want everything. If there's a blank in there, there's a reason that it needs to be filled out. If there's not a reason that it needs to be filled out, then scratch it and initial it. Make sure that the other party initials any changes. So as you're going through the terms of reviewing the contract, if you last minute change something, both parties have to initial that change. Make sure that that's clear. Otherwise, the change won't apply. And then make sure you get a copy of the contract that you retain for yourself. There's limits of how long you can retain or you need to retain that information. Understand that too. So Contract amendments, we talked about that. I'm going to hit this real quick. It is, again, as you're going through the process, as things change, it's important to document what changes and why it changed and how it changed the terms of the original contract. And there's amendments. A lot of them are boilerplate, easy to find and produce. They're usually part of the contract, how you do amendments, or someone, an owner or client will do them for you. But don't let time pass without documenting that there's been a change in the agreement, because it could affect how you get paid, when you get paid, what you get paid, how much time you have. It could affect a lot of those things. So it's important to just keep up with those and don't procrastinate on getting changes done. Don't allow that to happen. And then the most important thing to me is understanding when your obligations are complete. Those obligations in writing change as it relates to the contract. That's one thing, but I think you should talk to your attorney about what the tail, they call it a tail, what obligations extend past the end of your contract, because there are state statutes or laws that basically obligate you to extended warranties, things like that. And so understanding, what your obligation is for some of the work that you do, and learning about that, talking to people about that is important as your business grows. They can be terminated for a lot of different reasons. Both parties agree, or you get into the project, it doesn't really start because of frustration. They call it frustration, but in this, I'm calling it frustration here, but the reality is that you just can't seem to get the project started. So you decide, let's just agree to disagree, or let's not get started and let's just forget this contract. It can be done for convenience. Any party, when you look at most contracts, there's a term that's termination for convenience, and then there's one for, for cause. Under convenience, there's ways that you can be compensated if they stop the project halfway and you still haven't been compensated well, or you feel like you've lost opportunity in the business. You need to negotiate those terms and what happens if they decide to terminate for convenience. That might be a lot of information, but I think just understand that those are options that every party should have in a contract. Or due to breach, if the opposite party doesn't do what they say they're going to do, you can call them on it. You can send them a notice and ask them to respond to why they haven't abided by the contract within a specific time. Those are terms that are in the contract. So, and that leads you into kind of the next steps of what you do, whether you move forward or not. So 10 key conditions that are typical that I look at is scope of work. Again, this is more of a checklist for you. It's a little bit of a repeat of some of the things that we talked about. It's understanding what the scope of work is, looking for things that are time related. And these words, time is of the essence, are very unique words. And so if you see the words time is of the essence, make sure you understand what you're signing, because what it does is it raises the schedule to another level with these words. It means that you're agreeing that you understand that they need this project done no matter what by a specific time. So you need to make sure that you understand, what your obligations are. Liquidated damages, what are your penalties if you don't finish on time? Because you need to work that. That sometimes can be good and sometimes it can be bad. I use liquidated damages to help promote the importance of finishing on time with subcontractors or other consultants or partners that we have on the contract. So we're all in it together, working towards completion, understanding that somebody's going to have to pay if somebody doesn't do their job. Insurance indemnifications is a big word, complicated. This is the type of thing that I generally talk to my attorney about based on the contract. Reimbursables, warranties, who handles fees if there's an issue. So these are just some things to kind of look out for. Use this list as you read contracts, set it aside, look for these clauses in your agreements if you're signing a full-blown contract, to really understand kind of what your obligations are. So that's what these lists are for. So quick case study. I worked on a project probably about 12 years ago where we went through this process of managing the contract, and I want to show you what happened on that contract, just so that you can understand how important going through this process is and what the possible consequences are if you don't do this right. So the project was a project on South Padre Island. It was a 134 unit high-rise condominium, beautiful building. We started construction in January. I was working with a different company. I was not with Tejas, by the way. And we started the construction in 2007. And at the time that we negotiated the contract, these were the 4 issues that we were keyed in on for negotiating. We were concerned about legal issues that related to the fact that this was a condominium building because it has a different set of rules associated versus a commercial building. Homeowners have a different set of rules that they go by with respect to contracts. So we were trying to make sure that we limited our liability there. We had big liquidated damages on that, so we were trying to make sure that we understood what that was and how to maneuver through that. We were really concerned about payment terms. This was a private developer who had never done a project like this. Great guy. I still speak to him. He's still a friend, and have a lot of respect for him for the way that he handled this project. But we wanted to make sure that we were keyed in with all the people that were passing money around, the banks, everybody else. So we knew what it took for us to get paid. And then really clearances with the general land office. We had a lot of issues with the location of the building, and wanted to make sure that we weren't obligated for a lot of different reasons on how this building, the location of the building, because adjacencies to the ocean, things like that. So this is really what we thought at the time that we started negotiating the contract were the important issues to follow. This is the building on the left. This is the construction that was going on. Beautiful building, had a lot of fun building it. But a few months after we got the structure topped out, we started to notice some issues. And I was there when some of these failures were happening, and it was something that I'd never seen before in my career. So you can see from the images, this is pretty brutal. I mean, it's not a good situation to have when you have a high-rise building. This is really where the building stood for almost a year. We stopped construction. We had to stop construction because of the magnitude of the failures. We had to stabilize the building and let the attorneys, insurance companies, and everybody go through their process to understand what the issues were with the building, to see if the building would be able to be repaired. So basically what was happening, the foundation was failing. It sunk, the center of the building only had sunk 16 inches, which made for differential displacement between a garage and the tower. If you remember, there was a garage on the left-hand side on that tower, so there was differential movement from those, which created all of that failure of those concretes and the concrete reinforcing everything else that you saw in those images. So at one point, the county had essentially considered the project a safety hazard to the community. So they were concerned that at some point it would start to collapse. We worked for the insurance companies at that point. What we relied on in the contract terms under the circumstance were the insurance clauses that we had negotiated, the bonding clauses we had negotiated, the design liability clauses we had negotiated, the unforeseeable conditions clauses we had negotiated, and really making sure that our subcontractors and vendors were able to be paid for the work that they had done. And that had been all negotiated in the contract. We didn't know that we were preparing for a situation like this, but as it turned out, this was our standard for negotiating contracts, and it proved to be very helpful. On December 13th, the building was imploded. So we were actually hired to implode the building. And this is what happened. So it looked like this. It's kind of a boomerang view. It was in a sense heartbreaking, but there was a silver lining to this, in that what the owners had really contracted us to do was this building on the left, and they wound up with what's on the right. And in that, you can imagine as a contractor, our huge concern, or the most important concern, this could be a catastrophic event for a company, almost kill a company because of the consequences of being involved in a project like this. But for us, it was actually not a bad thing, because we had negotiated a contract that was very clear on what our obligations were and what other people's obligations were. And so there was no impact to our company. We had no liability. It turned out that there was an issue more from the design perspective on some of the testing that had been done in advance that was used to design the structure, and that's where the liability lied. So as a contractor, we actually walked away from the project with no monetary damage or no reputation damage. We'd pretty much been cleared. The group that took the biggest brunt of the damage was the lender. That's just the way that these deals work sometime when they get to this point. But again, we were cleared of everything. So quick final thoughts. I leave a few minutes for some questions and answers, but read your contract, bring in an attorney when you need it. You see the list, negotiate, be careful how you negotiate, make sure you have the right people at the other end of the table. Make sure you do amendments, close it out, and don't sign anything that you feel makes you really uncomfortable, which I call sell the farm terms. When you think about it, if it's the type of thing where the consequences are you have to shut your business down, it's not worth it. So that's really, I don't know, I left a few minutes for questions and answers. I'm going to let the Maestro staff tell me if we're getting any responses. Let's see a chat. Oh, shit. It looks like I went through that whole process without sharing my screen.
Hi, Renee.
Sorry about that.
I actually, well, I had your presentation, so I
Okay.
was able to share it for our attendees. And so I'm monitoring our questions. Right now, we don't have any, but let's see. See if we get any in. Okay, we have one question. Could you share an example of something you learned from a contract that you didn't realize going into it?
I mean, that happens all the time. And I think, so I think the way I'd answer that is that the good thing about a lot of contracts that we use in construction is that they've gone through the process of being tested. So if you're using AIA or consensus doc from AGC or an owner's or a contract, if you're a subcontractor, if you're using their forms of construction, they generally, like I've kind of expressed on this Ocean Tower project, they generally have the boilerplate has all the things that can happen pretty much covered. So I can come up with 100 examples of things that happened. This Ocean Tower building is a great example of things that you don't anticipate are going to happen. But the biggest thing that you're always looking out for are the unforeseen things. Like sometimes you're not taking into account environmental issues that you could uncover. If you're doing a renovation of a building, that's like always a big issue. You uncover something that nobody knew was there. And what do you do about that depending on the magnitude? So it can be anything and everything. And I think it's different for every type of business that you're in. So.
And Renee, I have a question on that South Padre building. What was the time frame again on that before they built it up, they realized that it had those structural issues, and then they also contracted you to demolish it. So what was the time frame on that?
It took about a year, probably a little over a year, to get to the point where they had they basically brought in several consultants, first of all, to validate whether we as a contractor had done everything that we were obligated to do. And so there was a series of consultants that came in to look at everything that we did. And then we were finally cleared. And then it took another 6 months just to figure out what was causing it, because they needed to figure out who to blame, essentially. And that's where so it was over a year before they finally decided that, settled all the claims, decided that what needed to be happen was for the building to be imploded. So it was a while, and it was a lot of meetings and a lot of attorneys. But fortunately for us, it wasn't catastrophic. So
That's great.
yeah.
Well, thank you for your presentation. I hope everyone enjoyed it. This presentation will be available, the recording of it, through our agenda for up to 3 months. And so you're able to view it. If you want to share it with any of your colleagues, please feel free to do so. We'll also be uploading this recording to our website at maestrocenter.org, where we'll have a landing page for all our construction conference speakers. And we will be opening a community topic on contract management. So Rene, if you have some extra time, feel free and pop in and engage with our attendees. And thank you again so much for volunteering your time and your expertise to Maestro in this construction conference.
You're welcome. Thank you for having me.
I appreciate you.
All right. Bye-bye.
Have a good one. Bye, everyone. See you
Bye.
at the next session.